Good day, students, and welcome to part 2 of the online discussion of topic 2.3 and 4 of your banking law module. The purpose of online discussions is to merely guide you through certain parts of the module. It is by no means a comprehensive discussion of all the material you need to study. With the online discussions, we focus on making it easier for you to study and work through the different topics. It is ultimately still your responsibility to master each topic. Constantly check My UNISA for additional material that may be prescribed during the year. In part 2 of the online discussion for topic 2.3 and 4 of your banking law module, we will focus on the main exceptions to the autonomy principle of letters of credit and demand guarantees. The main exceptions include fraud and illegality of the underlying contract. A letter of credit and a demand guarantee are particular instruments in which the liability of the issuer or guarantor to pay is not dependent upon genuine default of the principal debtor. The issuer or guarantor promises to pay a primary or independent undertaking to perform the principal's obligations, regardless of whether or not the principal debtor's obligation is enforceable. If the payment obligation is of this nature, the promise to pay will be enforceable, whether or not that of the principal debtor is enforceable. In general, the issuer or guarantor of such an instrument agrees to pay the beneficiary a sum of money on the beneficiary's submission of documents or a statement of demand in writing that the principal debtor is in default to perform the underlying contract, and real proof of default is not a requirement. The guarantor issuer is compelled to pay if a complying demand is made and may only thereafter raise any argument between the parties about the underlying contract. The idea of a letter of credit transaction or a demand guarantee transaction is that if the documents presented are in line with the terms of the guarantee or the credit, the issuer or the guarantor, for example a bank or insurance company, has to pay. And if the documents do not correspond to the requirements, it must not pay. We refer to that as the documentary nature. Letters of credit and demand guarantees are treated as autonomous or independent undertakings. The operation will not be interfered with by courts on grounds immaterial to the guarantee or the credit itself, and this is referred to as the independence or autonomy principle. The documentary character of letters of credit and demand guarantees is interlinked with their independence principle. It briefly means that if the beneficiary submits a stipulated documents, in other words, the documents specified in the actual demand guarantee or letter of credit, which comply with the terms of the credit or guarantee, the issuer or guarantor is forced to pay. But if the documents do not correspond to the requirements, the issuer or the guarantor is not required to pay. This is in strong contrast to the suretyship guarantee. That is an undertaking to be answerable for the debts of another and is triggered only by proof of actual default and is not independent of the underlying contract. Now, the surety of a traditional guarantee, such as a suretyship, undertakes or promises that the principal debtor will perform his obligations to the creditor or the beneficiary, and that he, the surety, will be liable to the creditor to pay a sum of money to the creditor or the beneficiary, or alternatively to perform the beneficiary debtor's obligations in terms of the underlying contract after the failure of a party to perform the underlying contract, provided the beneficiary is able to show that the principal debtor has failed to perform his part of the contract, and then only to the extent of the principal debtor's liability and subject to any defences available to the principal debtor. In this manner, the surety's liability to the non-performance of the principal debtor's obligation is accessory or coextensive to the principal debtor's obligation. If the principal debtor's obligation does not exist or is void, diminished or discharged, the same will apply to the obligation of the surety. In simple terms, this means that for there to be a valid suretyship, there has to be a valid principal obligation between the debtor and the creditor. Now, a limited number of exceptions to the autonomy principle of demand guarantees and letters of credit exist. In other words, in certain circumstances, the autonomy of demand guarantees and letters of credit may be ignored by the bank or the guarantor or the issuer, and regard may have to be the terms and condition of the underlying contract. For example, in demand guarantees, it would be a construction contract, or in letters of credit, the sales agreement. Now, main exceptions concern fraud and illegality in the underlying contract. The grounds for non-payment under a commercial or standby letter of credit often also constitute grounds for non-payment under a demand guarantee and vice versa. The only international accepted exception to the autonomy principle, however, is fraud. However, certain other countries, for example, Singapore, Malaysia, and Australia, also accept other exceptions to the autonomy principle. For example, the underlying contract is a nullity or unconscionable conduct. It is a valid defense where the guarantor or issuer of a demand guarantee or letter of credit refuses to pay if the demand or document submitted are defective or submitted late. But in these instances, where there is ineffective documents or wrongful documents or documents that do not comply with what is stipulated, it will not create an exception to the independence principle. And there it will just merely be non-complying demand that the guarantor or issuer does not have to honor. If we deal with fraud as an exception, as mentioned, that is the only international exception all the jurisdictions agree on. It is also well established in South Africa. Now, the South African courts take the stance that it is for the bank or the issuer to decide whether it should refuse payment on the grounds of fraud or forgery. The issuer is obliged to pay where a compliant demand for the payment is made and the evidence of fraud is insubstantial. However, if the forgery or falsification appears from the face of the document, the issuer or guarantor is permitted to refuse payment, even without a court interdict. If fraud is discovered before any payment is made by the issuer or guarantor and separate of the right of the issuer to refuse payment, an applicant of the letter of credit or demand guarantee may also apply for an interdict to restrain enforcement of the credit by the beneficiary. But that will only be if he can prove that fraud, and that is established fraud, on part of the beneficiary of which the issuer or the bank has knowledge. The fraud must also have been committed by the beneficiary and not by a third party. If payment was made already on the demand guarantee or letter of credit, the applicant can also apply for an anti-dissipation interdict under the South African law to attach the money of the beneficiary to not permit him or her to use the money until the matter is decided. Now, the South African courts are prepared in cases where fraud has been established, not only to interdict the beneficiary from receiving the payment, but also from making a demand, and also to interdict the bank from paying. The first case in South Africa to deal with the fraud exception was the Phillips versus Standard Bank case in 1985. However, it was not until 1995 in the Loomcrafts Fabric versus Netbank case where the appellate division, as it then was known as, truly acknowledged and dealt with the fraud exception. Now, the Loomcrafts judgment did not cover all the aspects of fraud exception, and many uncertainties regarding fraud, for example, the exact concept of fraud and the exact standard of proof, remains unsettled. Nonetheless, what the judgment did settle was that the South African courts would consider intervening and issuing interdicts restraining payment in cases where the fraud was clearly established, and would be willing to enforce the fraud exception where the forgery or falsification concerned the document. Loomcraft also made it clear that courts would restrain an issuer from paying under a letter of credit only in exceptional circumstances. Many years followed before the courts again got the opportunity to address the fraud exception. In June 2009. The Lombard Insurance versus Landmark case dealt with the fraud, and the Supreme Court of Appeal made various important statements. The court, for example, said, the guarantee by the guarantor is not unlike irrevocable letters of credit issued by banks and issued in international trade, the essential feature of which is the establishment of a contractual obligation on the part of a bank to pay the beneficiary. The obligation is wholly independent of the underlying contract of sale and assures the seller of payment of the purchase price before he or she parts with the goods being sold. Whatever disputes may subsequently arise between buyer and seller is of no moment insofar as the bank's obligation is concerned. The bank's liability to the seller is to honor the credit. The bank undertakes to pay provided only that the conditions specified in the credit are met. The only basis upon which the bank can escape liability is proof of fraud on the part of the beneficiary. The exception falls within the narrow compass and implies where the seller, for the purpose of drawing on the credit, fraudulently presents to the bank documents that to the seller's knowledge misrepresents the material facts. Now, the South African courts make a clear distinction when it comes to fraud between fraud committed on the documents, and we refer to that as fraud in the narrow sense, on the one hand, and on the other hand, they also make a distinction between fraud committed by the beneficiary that does not pertain to the documents but relates to the conduct of the beneficiary on the other hand, and that is fraud in the wide sense. From the cases dealing with the fraud exception, particularly involving letters of credit, so far it is easy to make the deduction that the courts are willing to enforce the fraud exception only where the forgery relates to the falsification or forgery of the document presented in terms of the letter of credit, and that is fraud in the narrow sense. But South Africans have not yet decided that they are not willing to interdict a bank from paying in the case of fraud concerning the conduct of the beneficiary in terms of the underlying contract, in other words, fraud in the wide sense. There is also past authority indicating that the South African courts may be willing to also consider fraud in the wide sense and look beyond just the forgery or falsification of the documents presented in terms of the letter of credit in considering whether there was any fraud on the part of the beneficiary. It has convincingly been argued that courts are likely to also support the view that fraud justifying interference with the beneficiary's claim to payment is not only limited to forgery or falsification of the document, in other words, fraud in the narrow sense, where it involves letters of credit, but would also include permitted by the beneficiary in the underlying contract, fraud in the wide sense, were the courts presented with such a case for decision. Such a case has not presented itself to court yet. So although the South African courts generally seem to restrict the operation of the fraud exception to fraud in the narrow sense when it comes to letters of credit, they are more accepting of fraud in the wide sense, in other words, in the underlying relationship when it comes to demand guarantees. In fact, the courts have already accepted established fraud in the wide sense as an exception when it comes to demand guarantees. For instance, in Group 5 versus the member of the Executive Council for Public Transport, Roads and Work, Gauteng, the court recently accepted that the only possible deduction in that case was that the beneficiary of a demand guarantee had acted fraudulently in the underlying contract. Although South African courts have acknowledged or dealt with the fraud exception regarding letters of credit and demand guarantees, the Group 5 case is to date the only case where fraud was successfully proved, albeit it was a case dealing with demand guarantees. Now, South African courts generally distinguish disputes regarding an innocent breach of the underlying contract and fraud. And a plain dispute is not equated to fraud unless it is the only realistic inference that fraud was committed. English law continues to play an important role in the development of the law relating to letters of credit and demand guarantees. In South Africa, the standard of proof for fraud is developed similar to that of the English law. And in both jurisdictions, the standard of proof required is very high. In South Africa, established fraud on the balance of probabilities provides an exceptional circumstance for an issuer to escape the liability to pay. South African courts are willing to grant interdicts if fraud is established, but they are also willing to go to great extremes to protect the integrity and independence principle of letters of credit. In South Africa, it has accordingly been very challenging to prevent fraudulent demands for payment being made by beneficiaries on bank. On top of proving that there is established fraud on an application, applying for an interdict against the grantor issuer or the beneficiary must also comply with all the other fixed requirements regarding an interdict before it may be granted. The South African law relating to interdict is quite similar to the English law of injunctions, and it is difficult in both jurisdictions to obtain interdicts to either prevent an issuer or guarantor from making the payment or a beneficiary from making a demand. Akin to courts in England, South African courts always consider all the requirements for an interdict together, and they do not judge any of these requirements in isolation. And even if all the requirements for interdict are met, the courts will always have a wide discretion to grant or decline an interdict. The standard of proof in the context of interdicts is the ordinary civil one, which has to be discharged on a balance of probabilities. However, regarding interdicts relating to letters of credit based on fraud, it has been argued that the degree of proof that is required is even more strict than what is normally required of civil cases. However, precisely how much more convincing the evidence must be for granting an interdict remains unclear in South African law. It is, however, very difficult to obtain an interdict under the South African law. The fraud exception under South African law regarding letters of credit and demand guarantees is not entirely settled, and there are still indecisions in respect of the scope and precise application of the fraud exception. Nevertheless, what is sure is that the standard of proof is very high and will not be inferred easily, and interdicts are only granted in exceptional circumstances. For a very short period of time, our courts also accepted other exceptions besides fraud. Now, the existence of other exceptions besides frauds differ from jurisdiction to jurisdiction. For many years, South African courts were extremely hesitant to acknowledge any exception to the autonomy principle other than fraud. That was, however, until the Supreme Court of Appeal delivered its majority judgment in the Dormel versus Renaza insurance case. The court recognized another exception to the independence principle in that case. It held that if a court of law or arbitrational tribunal has pronounced finally on the dispute between the contracting parties about the underlying contract, the decision of the court or the award of the arbitration tribunal could be relied upon as a defense by the guarantor or the issuer. Klüter delivered a minority judgment. He, however, disagreed, and he was forceful in giving effect to the autonomy principle, subject only to the fraud exception. He did not agree with the majority to allow a further exception to the autonomy principle. This was the main difference between the majority and minority judgments in the Dormel case. The majority recognized the additional exception to the autonomy principle, but the minority did not, accepting fraud as the only valid exception. However, in subsequent judgments delivered by the Supreme Court of Appeal, the opinion was expressed that the majority judgment in Dormel was wrong and that the minority judgment was preferable. These expressions initially had only persuasive value, but in Coface versus East London Own Haven, the Supreme Court of Appeal eventually retracted its ruling on the issue and held that the majority judgment in Dormel was actually clearly wrong. It should, however, be noted that information on an arbitration award or a court order could be important in certain instances and certain cases, and it could, for instance, be argued that it could make out a form of fraud, and if it constitutes fraud, it could form an exception to the autonomy principle. Illegality as an exception. If we deal with that, It is not certain in all jurisdictions whether it is an exception to the independence principle if the demand guarantee or the letter of credit itself and or its underlying contract is contrary to the law, in other words, illegal, against the good morals or public policy. To determine whether or not these grounds will constitute an exception to the independence principle of the demand guarantee, it is important to differentiate between cases where it is the demand guarantee or the letter of credit itself that is illegal or against the good morals or public policy, and cases where it is the underlying contract that is illegal or against the good morals or public policy. It is established law in South Africa and England that a contract that is contrary to the law, public policy, or good morals is illegal and therefore void in terms of the general principles of the law of contract in each individual jurisdiction. An illegal contract does not give rise to an action, and a court must refuse to give effect to it. In short, no action arises from a shameful act. By implication, it thus follows that if it is the demand guarantee or letter of credit itself that is contrary to the law, public policy, or good morals, in other words, the law of the country that is applicable to the guarantee, or the law of the country where the guarantee is to be executed or performed, it will not be enforceable. A demand guarantee or letter of credit may be rendered illegal by law in the place where it is to be paid, prohibiting payment under the guarantee or credit. Such illegality can be an existing or supervening event, and in either event, the guarantee will be rendered null and void. A supervening statutory prohibition often happens where a government decides to impose trade and financial sanctions against a specific country. Such a sanction could prohibit payment for a certain time period, but could even continue after the sanction has been lifted. A demand guarantee or letter of credit itself may also be illegal, for example, where the issuing of the guarantee or credit is forbidden. This will be the situation where it is against a specific legislation to issue a demand guarantee or letter of credit in favor of beneficiaries from a specific country. For example, when the beneficiary is a citizen of a country deemed to be a foreign enemy of the state, or the outbreak of a war makes the beneficiary such a foreign enemy. Where the demand guarantee or letter of credit is itself illegal, but the underlying contract is legal, the principle of independence does not come into play, and no problem arises as a result of that principle. Furthermore, if both the demand guarantee or letter of credit and the underlying contract are illegal for the same reason, for example, under the same prohibition, the illegality of the demand guarantee or letter of credit is not influenced by the independence principle, because the guarantee is illegal itself, instead of through illegality in the underlying contract. It has also been argued correctly that South African courts are unlikely to arrive at a different conclusion regarding instances where the guarantees or letters of credit themselves are illegal. Illegal underlying contracts might and may constitute an exception to the autonomy principle. Now, a problematic situation arises where it is not the demand guarantee or letter of credit itself that is illegal, contrary to public policy or good morals, but rather the underlying contract, for example, the sale of illegal ammunition or the sale of drugs, or to enable drug trafficking or money laundering, if that is the underlying contract. It is sometimes reasoned that because a demand guarantee or letter of credit is independent of and distinct from the underlying contract, the illegality or it being contrary to public policy or good morals of the underlying contract is unrelated to the enforceability of the guarantee or credit. However, if one were to accept this reasoning, it would mean that the issuer or guarantor will be permitted to ignore the illegality of the underlying contract and will thereby be supporting and condoning the illegal objectives of the parties to the underlying contract. Until recently, it was uncertain whether illegality in the underlying contract can or should constitute a valid exception to these instruments' independence or autonomy principle. From earlier English case law and scholarly discussions, it appears that the acceptance of such an exception is very contentious, and even if it is recognized, its extent remains uncertain. The English courts have previously indicated they are open to accepting illegality in the underlying contract as an exception to the principle of independence of demand guarantees and letters of credit, but have not developed the same parameters of such an exception. In the past, there were no South African court cases where illegality in the underlying contract was accepted or even considered as a possible exception to the autonomy principle of demand guarantees or letters of credit. However, a couple of South African scholars favored the acceptance of such an illegality as an exception. In a recent South African court case, Mattress House versus Investec Property Fund, we find the first evidence of a South African High Court's willingness to accept the possibility of illegality in the underlying contract as constituting a valid exception. It has been suggested that if the issuer or guarantor has actual knowledge of the illegality of the underlying contract, for example, where it is evident from the information supplied by the applicant in the application form for the demand guarantee or letter of credit that certain foreign exchange regulations will be broken by the issuer or guarantor if it complies with its payments instruction under guarantee, it should decline to honor it. It has been correctly argued that one should distinguish between a situation where the underlying contract is merely invalid or unenforceable, but not also illegal. An invalid underlying contract has no effect on the validity and enforceability of the obligation in terms of a demand guarantee or letter of credit itself. Where the underlying contract is illegal, it is important to first establish whether that illegality is serious, and if so, to establish thereafter whether it also extends to and influence or taints the demand guarantee or letter of credit itself. If the demand guarantee or letter of credit is indeed affected by the illegality in the underlying contract, the principle of dependence of the guarantee or credit may be infringed. The Mattress House case illustrates that depending on the seriousness of the illegality in the underlying contract, there are instances where the guarantor or issuer will still be obliged to pay in terms of the dependent payment obligation set out in the demand guarantee or letter of credit. It also confirms that the type of illegality that would constitute an exception would have to be something containing a criminal element, or at the very least, furthers an unlawful purpose. Now, recently, South Africa also saw other cases where other further exceptions to the autonomy principle were raised or accepted. In the Schulze case, Schulze Pumps versus Kovek case, it was seemingly held that a beneficiary could also be prohibited from making a demand for payment upon a demand guarantee where he or she was acting in bad faith, unconscionable, or had even made a contractual promise not to call upon the guarantee. The court in Holland Insurance versus Genie, the court also accepted that bad faith could constitute a potential exception. Now, to date, unconscionability and bad faith exceptions have not been expressly accepted as possible exceptions to the autonomy principle in South African cases. There is also no international consensus as to whether a breach of a provision in the underlying contract or in a separate contract, for example, if parties made a contractual promise not to call on the demand guarantee, to draw on the demand guarantee, and they contravene that, whether that would be an exception to the autonomy principle. This is commonly referred to the breach of a negative stipulation. Now, both English and South African courts, for example, in the Schulze case, and more recently, the judgment by the Supreme Court of Appeal in joint venture between Aveng and Straubach International, accepted that a beneficiary may be interdicted from making a claim on a demand guarantee in breach of a negative stipulation, either expressly or impliedly. It is unlikely that such acceptance creates a further type of exception, in our view, to the principle of autonomy. In our view, it rather creates a distinct type of case where calls for resolution by the parties to the underlying contract and where the party making the call may be interdicted. So this further exception will be dealt with in part 3 of the series of online discussions dealing with topic 2.3 and 4 of your banking law module. I therefore thank you for your kind attention and I wish you well for your studies.